You are on bond for DWI, and you've now picked up a new DWI. Sir. You were charged again. You're facing up to 6 months in jail and or a $2,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir.
Thank you, Your Honor. On April 24th, 2025, in Harris County, Texas, law enforcement officers were dispatched to a crash. The law enforcement officer spoke with a complaining witness who stated he had gone to the bathroom and heard the defendant crash into the bus. The complaining witness was the bus driver. The complaining witness estimated the damages to be $1,000. Another witness saw the defendant strike the bus, get stuck between the bus and another vehicle, and then exit the driver's side door and try to push the vehicle out. The witness stated after another individual.
And right out the gate, the judge drops a bomb, a second DWI, while already on bond for the first. If you know Texas, you know judges take repeat DWIs like a personal insult. Watch closely. This is where the tone of the entire hearing shifts.
Told the defendant they were calling the police. The defendant fled. Another law enforcement officer was alerted to the incident and found the defendant, who matched the description given. A witness was able to identify the defendant as the individual driving the vehicle that struck the bus. Another law enforcement officer made contact with the defendant, who stated he was coming from an Astros game where he drank. The law enforcement officer observed a moderate odor of alcoholic beverage, glossy eyes, and profuse sweat from the defendant. The defendant refused to cooperate on standard field sobriety tests. The defendant refused to provide a specimen. A blood warrant was obtained and executed.
Mr. Gallegos, I'm going to find it privileged to drive.
Pause.
You are not allowed to drive at all.
Bus,
Do you understand me?
Between cars.
On one ankle, I'm going to put a scram monitor so I know that you're not consuming alcohol.
Out.
On your other ankle, you will get a GPS monitor, and I'm giving you a curfew because I don't want you out in the middle of the night. And if I find that you're out, I will revoke your bond. There's sufficient probable cause to go forward with the case. I am now taking away your privilege to drive. You are not allowed to drive at all. Do you understand me? Yes, on one ankle, I'm going to put a scram monitor so I know that you're not consuming alcohol. On your other ankle, you will get a GPS monitor, and I'm giving you a curfew because I don't want you out in the middle of the night. And if I find that you're out, I will revoke your bond and make it extremely high. He's on bond for this DWI. Yes, I'm revoking his bond. You're going to
legal insight. When a judge says he's taking away your privilege to drive, that's the start of bond modifications. And judges have wide discretion here. But watch what happens next. This isn't just a stern warning. It escalates fast.
Jail today.
Right now?
Right now.
Okay, as far as the monitors, can we waive the fees?
Absolutely. Of
course.
Can you give my stuff to my mom?
Yes.
So these are conditions. We'll have him sign now. The GPS monitor prior to release.
Are you setting the bond to him?
Of course. Mr. Gallegos, I want you to understand something. This is an affidavit that you're going to sign to me, that you're going to promise to me you're not going to drive. I don't give a rat's behind what your excuse is. If Jesus comes from heaven and needed to ride to church, you drive. I can have a contempt hearing. You can be facing an additional 6 months in jail and a $500 fine every time you drive. Do you understand? I am now also sending notice to DPS that I'm placing a restriction on, you're not allowed to drive, but I'm placing an additional restriction on your license that you are not allowed to drive any vehicle that doesn't have an ignition interlock on it. This notice is sent to DPS so that every single officer in the state knows that if you are in a vehicle driving, they pull you over, you don't have an interlock, they will take you to jail. Do you understand? As it stands, you are not allowed to drive for any reason. Okay, we'll have him sign this. We'll put him in back. I'll set the bond and then,
Take my card. Yeah, and look, we'll start more around. We'll handle this when I do get the.
All right, Judge.
get whatever date you want on the new cases.
Okay.
When he posts bond on the old case, feel free to get in touch with the, and then you can put the date
Just
for
one
whatever.
together.
Yeah,
What are
He-
you setting the bond at? I'll tell it.
5,001.
5,001.
Yeah.
Both cases or just the?
He just, no. The two new ones, I'm not gonna touch. I'm gonna leave it as is. He's made a bond basis, so we're only gonna do the old DWI 5001. Actually, we're gonna need, he signed conditions now, so when he gets out, he'll have,
those.
yeah,
Okay.
because we'll give him a copy of the conditions now.
Okay,
So they just feel free to let her, whatever date you get,
okay.
after he
And then
gets out,
it's
just
out.
get, yeah.
Okay.
Hi,
I'm here for Francisco Hernandez.
Okay.
He's here for a bond violation.
okay, come up, Mr. Hernandez. It's Hernandez or
Mr.
Roxanne? What the?
For something positive for THC.
That's it.
That's it.
Okay. I'm giving you a pass for 50 days from the time that we ordered you not to in
Fire,
January.
there it is. Instant bond
He
revocation.
tested positive
No apeados,
on April 7th.
no extensions,
Or not, on
no
April 14th,
bargaining.
rather.
In Texas courts, this is the
Okay,
equivalent
but he's still
of the
testing
judge
positive, he's still
slamming
using when we
down
ordered
the
him not to
emergency
use.
brake. It's rare to see it this quickly, but
Yes,
repeat
Judge,
DWIs
I understand that
leave
THC can
judges
take
with
up to
little
30 days to
patience.
work out of.
Use, don't use. Do you understand? So we ordered him not to use when? He's still testing positive. We ordered him not to use in January.
He tested positive on April 7th, Judge. Or not, on April 14th, rather. The-
Okay, but he's still testing positive. He's still using when we ordered him not to use.
Yes, Judge, but I understand that THC can take up to 30 days to work out of urine. So there's no evidence that he's been using beyond the,
I ordered him not, let me see, hold on. I ordered him not to use in January. We are now,
yes, Judge, but you've already addressed his drug use that resulted in the positive result on the April 14th drug test. You addressed that by chastising him in court and issuing several additional bond conditions. There's been no evidence that there's been any additional drug use for the court to address.
if I tested him in early January, then I'm gonna have an issue. But if it's the first time I tested him was in April, then I'm gonna give him the 50 days from the first time that we tested. But if I tested him early on and he tested positive and I admonished him not to use and he's still testing positive, I'm gonna have an issue. I don't remember when the first time we tested him, so I'm gonna ask her. Roxanne, on Mr. Hernandez, when was the first time we tested him, please?
When he first tested positive for THC?
Yeah, when did we first test him?
Oh, it was March 11th of this year.
So March 11th was the first test, and that was positive for,
Negative.
that was negative.
Yes, it was negative. And then on April 7th is when he was a no-show. And on April 14th, it was confirmed by lab that he was positive. for
No,
THC.
you're using. I'm sorry. I'm revoking your bond. You're going into custody.
I could just ask the court Mr. Hernandez's mother is out in the hallway. I'm certain that she's going to pay whatever the bond is. This, revoking the bond here will only have the effect of punishing, his mother who will have to pay the bond. And I'd also just ask the judge, you to consider that I understand that there may be evidence that he's used since he was ordered to not use. I understand that. But, there's no evidence that he's using now or that he has used in the more than 2 weeks since the prior drug test.
We just tested him yesterday. He tested positive. He tested positive a week ago. I've ordered him not to use. I mean, if I don't, then I'm rewarding him for his behavior, Mr. Schlossberg. That doesn't make any sense. You know, I understand that it's punishing mom. These are the things that you need to consider when you're out there. I told you not to use, and you're now using. Goes with you. I'm sorry, Mr. Schlossberg. I can't just continue to let people go.
Judge, the drug test yesterday, it came back positive for THC because it was within 14 days of the previous drug test on the 14th.
He tested negative the first time we tested him, and now he tested positive for using.
And here comes the emotional tension. The defense argues that revoking bond hurts the defendant's mother more than him. This is a common last-minute strategy, but judges are trained to separate family hardship from public safety risk.